and welcome to 5-Minute Family Law. Today's episode is about how family law disputes are resolved in British Columbia, including by going to court. First, however, it's important to understand that there are more ways of resolving family law disputes than just going to court. There's arbitration, mediation, and collaborative negotiation. I'll talk about each of these processes a little bit later in this episode, but what's important to understand is that each of them are, in general, cheaper, faster, and less destructive ways of resolving a family law dispute than going to court. The fundamental job of the court system is to hear and resolve legal disputes in a fair and impartial manner. There are 3 levels of court in this province, and each of them has a slightly different function than the other. The Courts of British Columbia. There are 3 courts in the province: the Court of Appeal, the Supreme Court, and the provincial courts. Trials are only heard before the provincial court or the Supreme Court, and in fact the provincial court isn't one court, it's actually 4 different courts, including family court and criminal and youth court. There are 2 appeal courts in the province, the Court of Appeal and the Supreme Court. Now, each level of court in the province is superior to the court below it, with the Court of Appeal being superior to the Supreme Court and the Supreme Court being superior to the provincial court. What that means is that the Supreme Court will hear appeals of decisions of the provincial court, while the Court of Appeal will hear appeals of decisions of the Supreme Court. Together, these are the Courts of British Columbia, with the provincial courts at the bottom of the pile, and the Court of Appeal and the Supreme Court collectively referred to as the province's superior courts. In parallel to the Courts of British Columbia are the federal courts, and just like the courts of the province, there is a trial court, that's the federal court, and there is a Court of Appeal, and that is the Federal Court of Appeal. Now, finally, above all of these courts, the federal courts and the Courts of British Columbia, we have the Supreme Court of Canada. This is the highest court in the country, and its job is to hear appeals from all of Canada's courts of appeal. And this is the court system of British Columbia. Of course, it's also a little bit more complicated than that. You remember the discussion about how there are 2 trial courts, the provincial court and the Supreme Court. Well, the provincial court is often the court that people go to first because there aren't any filing fees, the rules of court are relatively simple, and the forms are easy to fill out. But that level of court can only deal with questions under the Family Law Act, and even then it can only deal with some questions. It can only hear issues about the care of children, child support, and spousal support. Now, the Supreme Court is the other trial court in the province, and it has something called inherent jurisdiction. It can deal with everything under the Divorce Act and everything under the Family Law Act. So that court does offer one-stop shopping, but the problem is that filing fees, which can sometimes be quite expensive, are payable for every step of the process. The rules of court are very complicated, and the court requires much more close adherence to those rules, and the court forms are also a little bit more difficult and less easy to fill out. So the problem we have is that even though most people try to go to the provincial court first because it's easier, it's simpler, and certainly it's cheaper, the Supreme Court is the only court that can give you a divorce if you're married, and it's the only court that can deal with issues about the division of family property and family debt. Of course, there are other ways to resolve family law disputes than going to court. You could, for example, try collaborative negotiation. In this process, each party hires a specially trained lawyer to work with them and the other side to find a settlement of all of the legal issues. And along the way, you're able to hire expert third parties who can come and give advice to help you break log jams. For example, you might hire a mental health professional as a child expert to give advice about the parenting arrangements that are in the best interests of your children. Or you could hire a financial expert, like an accountant, to give advice to resolve a tax problem or help divide a complicated asset, like a small, closely held company. If you're successful, the result of the collaborative negotiation will be a separation agreement. A separation agreement is a contract which is binding and enforceable by the courts and is really in many ways just as good as getting a court order. Another way to get a separation agreement is through mediation. In mediation, you'll be working with or without your lawyers with a mediator. The job of the mediator is to help you talk to each other, to identify underlying interests, and to identify areas of compromise that might potentially lead to a settlement and, if successful, to a separation agreement. Finally, you could also try arbitration. In arbitration, you are hiring a third party as your private judge, and you agree that the arbitrator has the power to resolve all of the legal issues that you submit for a decision. The arbitrator hears your evidence and hears your arguments, and then makes a written decision called an award that resolves all of the legal issues you've given to the arbitrator to be wrapped up. And so we have 4 ways of resolving family law disputes in British Columbia. We have litigation, which means going to court and having a judge make an order resolving all of your family law issues. We have mediation, which involves going to see a neutral third-party mediator to help you and your ex talk to each other and hopefully reach a separation agreement. We have collaborative negotiation, where you and your ex hire specially trained lawyers who work with each other and with you to find a settlement. Then finally, we have arbitration, where you hire a private judge who you agree will make a decision about your legal problems for you.